Mr. Deputy Speaker, I declare my interest as a lawyer practicing in international commercial disputes and occasionally dealing with cases heard in the Singapore International Commercial Court, SICC. I support the primary aim behind this bill. The launch of the SICC in 2015 was a major move to position Singapore as a neutral dispute resolution center in Asia in the litigation sphere, in tandem with the arbitration sphere. Leveraging on our existing well-developed legal infrastructure and respected judiciary, which includes not just local judges, but eminent jurists drawn from outside Singapore. The establishment of the SICC heralded an exciting change in our legal landscape. This bill seeks to amend the Act to clarify that the SICC has the jurisdiction to hear any proceedings relating to international commercial arbitration that the High Court may hear. Given that the SICC's jurisdiction involves hearing commercial actions that are international in nature, there is no reason why the SICC should not also have the jurisdiction to hear proceedings relating to international commercial arbitrations involving foreign parties. This amendment is a timely one that brings clarity to this area. I do note, as the Honourable Senior Minister of State mentioned, that the SICC's jurisdiction to hear any proceedings relating to international commercial arbitration is proposed to be subject to conditions that will be prescribed in the rules of court. One condition that will be prescribed, as stated in the explanatory statement, is what constitutes an international commercial arbitration. Could the Honourable Senior Minister of State please elaborate on the other conditions, if any, that are expected to be prescribed in the rules of court? Next, on the issue of abolishment of pre-action certificate procedure, during the second reading of the amendment bill to establish the SICC in late 2014, the Honourable Law Minister explained that this was an optional step that a party could take in advance of commencing actual proceedings in order to mitigate any uncertainty in whether the dispute falls within the jurisdiction of the SICC. Now that the SICC has a few years of experience in administering international commercial disputes heard in that court, may I ask what has changed that has led to a determination that the pre-action certificate procedure is no longer needed? In particular, I wish to highlight that the pre-action certification procedure, besides promoting certainty in whether or not an action falls within the jurisdiction of the SICC, in terms of whether it's an international commercial case, also assists in promoting as to whether a case may be classified as an offshore case. This is because the pre-action certificate also allows for a determination by the court at the outset as to whether the case should also be classified as an offshore case, such that foreign representation would be allowed. By doing away with this pre-action certification procedure, the remaining two modes by which the case may be classified as an offshore case can only take effect after legal proceedings are commenced, namely by either party making a unilateral declaration that the case is an offshore case, or by either party applying to the SICC after the case has commenced for determination as to whether it is an offshore case. These two modes cause some uncertainty, as it appears that there's a lack of clarity as to whether a party who wishes to be represented by foreign counsel should do so from the outset after making an unilateral declaration, given the risk that it may be set aside later by the court. From another point of view, the other party to the action may also be taken by surprise, since he would not be aware as to whether the other party had applied to register foreign counsel, because this is an ex parte application. This means that the other party would not have advance notice of the other party's intention to have foreign representation until it's served with a unilateral offshore declaration. Even if that party were to apply to have the unilateral offshore declaration set aside, the other party's foreign counsel would nonetheless be allowed to act pending the determination of the application. This gives rise to the risk that even if the unilateral offshore declaration is indeed later set aside, the court may nonetheless exercise its discretion to allow foreign representation to continue, as is allowed under the rules of court. From the counterparty's perspective, this may be seen as a fait accompli. To promote greater certainty, it is preferable for any contentions as to whether the case is an offshore case to be raised and disposed of at the outset, either before the action is commenced or before the action is materially progressed. Subject to the points I have raised in my speech, I agree with the proposed amendments and I support the bill.